Hello there. Welcome to our webinar on estate and business planning. My name is Sonia Rustisi, and I am an associate paralegal with the James P. Seidel Law Office. Today I'm going to be talking with you about something that I feel very passionate about, estate planning. To help me do that, we have a very nice PowerPoint presentation, so let's get started. A little bit about our firm. Mr. James Seidel, who is the owner of the law practice, is a second-generation lawyer, and his father actually started the practice in the 1940s. Jim Seidel has been an attorney since 1980. He was also a former judge advocate with the Armed Forces, and he concentrates in estate and business planning since 1993. He has his Master's of Law in Taxation from William & Mary, and he's licensed in Virginia, Maryland, and the District of Columbia, and the United States Tax Court. He's also licensed before the United States Supreme Court. He's also a member of the National Network of Estate Planning Lawyers, and we'll talk about who they are in a moment. A little bit about myself. I've been in the area of estates and trusts for about 20 years. I worked for various law firms and lawyers across the Washington, D.C. metropolitan area, in Virginia, Maryland, and in D.C. I was also a bank trust officer for 5 years with the National Bank of Fredericksburg and PNC Bank. I'm currently full-time with the Seidel Law Offices as an associate paralegal. I graduated from Concord Law School with a Juris Doctorate degree, and I have a special expertise in probate administration, and I'm currently in the Virginia Law Reader program, and I hope to be able to sit for the Virginia State Bar. Mr. Seidel is a member of the National Network of Estate Planning Lawyers, and it is estimated that these are the best estate planning lawyers in our country. They formed this network, and Mr. Seidel has been a member of this since 1993. A member of this organization, we can bring that level of knowledge and expertise to our clients. And very sophisticated, specialized delivery systems to produce quality documents for our clients at a very competitive, low economic rate. Our firm has invested over $150,000 in the National Network's estate planning software and their collegiums. A major university did a study not too long ago and found out that 3 out of 4 Americans die without proper estate planning. So this is a very sad statistic, and what that means, and I'm going to show you here, is that when you don't have a proper estate plan in place, that's when the government or the courthouse will be making decisions for you and your family and your assets. And so you really want to avoid that, and there are some simple estate plan documents that you can easily put in place to allow your loved ones to control your estate when you become disabled as well as when you pass away. We have some handouts that are available on our website, which you can follow along with this webinar. Oops, sorry about that. Introductory Estate Plan Booklet. Here is an example, what I'm referring to. This is a very nice booklet that has some really good information about the differences between using a will and a trust to settle your estate when you die. Also provides good information about other documents that you need to have in your estate plan, such as financial powers of attorney and healthcare powers of attorney. So please be sure to get your copy of this book, and you can take a look at that during your downtime at your comfort and leisure. Another thing that you'll be able to take off of our website, which may be helpful, is a copy of the slides of today's presentation. And you'll be able to go back and look at those slides to refresh your memory as to what we talked about today. We also have an evaluation and sign-up form that looks like this. We're going to see a copy of that in a minute on the slide. And if you're interested in having a meeting with one of our staff, all you need to do is fill this form out and provide it to our office, and then someone from our office will contact you to schedule an appointment. Finally, you would be entitled to a discount for your legal fees. So this is what this blue form represents. And you're also going to be able to get a copy of this off of our website for listening to this webinar. Here's an example of the evaluation form that you'll need to fill out if you want to make an appointment with one of our staff members. So this is estate planning defined. What is estate planning? Essentially, estate planning is your ability to control your life, your assets, your stuff, if you will, when you become disabled, as well as when you pass away. Here we define that statement. I want to control my property while I'm alive, take care of myself and my loved ones if I become disabled. I want to give what I have to whom I want, the way I want, and when I want. And if I can, I want to save every last tax dollar, professional fee, and court costs possible. So exactly, estate plan documents do that. They put the control in your hands. You have the ability to name someone to manage your assets, manage your income, take care of you when you become disabled. These documents give you the ability to control who's going to control your estate when you die, and pass your assets to your loved ones, and how are your loved ones going to receive your estate. You can control all that with these documents. And obviously, if your loved ones are handling all this for you, there's no reason why the court or an attorney has to do these things, because courts and lawyers cost a lot of money. Your estate. So many times I have clients that come to me and tell me that they don't need an estate plan because they don't have an estate. They are confusing estate with having money, assets, and income, or a lot of it. And they think that if they don't have that, there's no reason to have estate plan documents in place for themselves. Well, they are very, very wrong. Your estate also consists of the human capital. You, your body, your spouse, your descendants, and others. So it's just not that an estate plan names someone to manage your money, your income, and your assets, but the estate plan is also going to name someone to be able to take care of you when you become sick and disabled and can't control your assets yourself. You have a document that says who you want to do that for you. So you may not have very much money or income, but these documents, you're going to name someone who you want to be taking care of you when you're disabled. Or your children and your spouse. Material capital, all kinds of descriptions here for these types of assets. Tangible assets, real property, your household furnishings, other intangible assets that may be royalties or patents or those types of things that you own. Business and investment assets, life insurance, and other benefits. So we all have certain assets that will need to be managed for us when we become disabled and when we pass away. Here are some sample estate planning objectives. We have our before death planning. Very, very important that you have documents in place for the before death planning. There's two parts to an estate plan. There's the before death and then there's the after death. And you have to make sure that you cover both parts. So the before death planning, that disability planning, is documents in place that say who's going to make your financial decisions for you when you become incapacitated, who's going to be making your medical decisions for you when you can no longer communicate to the doctor yourself. So it's very important to have that before death planning in place, the disability planning. After death planning, you need a document that says who's going to get your stuff when you die and who's going to be managing all of that, distributing your assets to the beneficiaries. So your documents will name a person to do that. Again, if you don't have a document that names who's going to be handling that after you die or who's to get your assets when you die, that's when, like I said a moment ago, when the government and the courthouse have to come in and handle that for you and your assets and your family. So your after-death planning can cover things like second marriages. If you want to make sure that your assets will go to your children from a prior marriage and maybe not to the your second marriage, or maybe you want your assets to be there for your second wife, but after her death, go to your children from a prior marriage. These are some of the after-death planning things that you can handle or you can put in your documents. Protecting a disabled spouse, protecting a disabled child, protecting the spendthrift child, a child that just is not responsible with money or has problems with addiction and other things like that you wouldn't want your child to receive a sizable inheritance. Estate tax planning. So if you have an estate that is very large, then you want to make sure that there is provisions in your documents that will protect your estate and your family from having to pay death taxes, either federal or state. Another objective, asset protection. You know, we're all about protecting our assets from predators and creditors and nursing homes and medical costs, of course. So there are some things that we can do with estate planning that can protect your assets from those types of problems. And then finally, planning for businesses and multiple properties. So if you are running a business, you have multiple properties in various jurisdictions, you want to make sure that your documents cover that. There are 4 types of estate plans. No plan, that's the government's plan, so we're going to talk about that in a moment. A will plan, okay, so that's part of that after-death planning. We'll talk about that as well. Poor man's estate, that's an odd title for a plan. We'll get into that. And then finally, living trust. Okay, so the first plan we want to talk about is no plan, okay, otherwise known as intestate. A lot of people don't have any documents in place that say who's going to take care of them when they become sick, who's going to settle their assets, and who gets their assets when they die. That's the intestate plan. I like to call this the government plan. Here, the government plan, state law is going to determine everything. You know, who's going to be taking care of you before you die if you're mentally incapacitated. We have statutes on the books that talk about that process. That's going to be a guardianship and conservator process over your body, your assets before you die. Because like I said, a lot of people don't have documents in place, and so the government has to step in at that time and handle that. The state law is going to determine who will serve as an executor of your estate when you pass, who the beneficiaries are going to be, and the timing of the distributions. Intestate plans are very expensive because the government's going to require that your executor administrator be bonded for the value of the estate. So that can make it very costly on your estate and on your loved ones, as well as it's a very long drawn out process, and we're going to see what that looks like in a moment. It's the least favorable estate plan, obviously, because it's a burden. It takes a long time for a probate to go through that probate process. It's very costly, as we described that. And unfortunately, it is the most common estate plan 2/3 of individuals have not done proper estate planning. So for about 12 years of my career, all I did was assist executors, administrators through the probate process. And so I can tell you want to avoid it. I'm very, very intimately aware of that process and the steps. And it normally takes, if you have a good lawyer working with you on it, it normally takes a couple of years, but could last as long as 10 years or longer. So it depends upon the professionals that you get to help you with that process, as well as the complexities of the estate assets. And you're really at the mercy of the court system. So you really aren't going to know for sure how long that process is going to take until you get into the court process. Now the next type of plan, a will plan. So this is a plan where you actually have a document. The last will and testament, we've all heard of the last will and testament as a document that says who's going to get your stuff when you die. So here we're going to see that, let me go back a moment. Let me see here. Okay, yes, so here, at least if you have a will, you get to decide certain things. See, without a will, the government makes all those decisions, like who's the executor, who the beneficiaries are, whether or not the executor is going to be bonded, and it's a more burdensome process. If you have a will, at least you can decide who is going to be the executor and settling the estate, or working with the government to settle your estate. You want to make sure that your will waives the bond, so that's going to reduce the cost on your estate. You want to make sure that your will names who the beneficiary is, and you want to have a contingent beneficiary in the event that the primary beneficiary is deceased or disclaims their inheritance. So also, you can, in your will, you can decide how your beneficiaries will receive their assets or receive their inheritance. So if you have minor children, if you have spendthrift children or disabled beneficiaries, you can certainly have a trust created within the will to hold that beneficiary's inheritance and be managed by a trustee for that beneficiary. The will is also important because it names who you want to serve as the guardian for your minor children or your disabled children. So the guardians are named in the will. So it's very important that your will handles that. And the thing is that if you don't have a will that handles these things or names these people, then it's whoever gets to the courthouse first, rushes to the courthouse and wants to be in that role, and the government may appoint someone that you don't want to be near you or your assets or your children. So it's very important for you to name these individuals yourself in your documents. Our will package is going to include 3 documents, or 6 if you're married. A will, if you're married, 1 for each spouse. A power of attorney, a financial power of attorney, 1 for each spouse, and the medical directive, 1 for each spouse. So our will package cover the before and after death plans. The will is the after death plan, and the financial power of attorney and medical directive are the before death plan. And we're going to talk more about that before death plan using these 2 documents here in a moment. So the power of attorney, the financial power of attorney, is a legal document that gives another person the power to make your financial decisions. It gives another person the legal authority to make your financial decisions for you. This person is called an attorney in fact, and then you are most usually referred to as the principal. Go back to that one just for a moment. This is a very important document. This is probably going to be your most important document. If you don't use a living trust, if you're going to use a will instead of a living trust, this will be the most important document that you have. because this is the only document that's going to keep you and your assets out of a government guardianship and conservatorship process. So you want to make sure that this document is strong, that contains everything that you think your agent, your attorney-in-fact, is going to have to do. You want to make sure that that document provides that. These documents are highly scrutinized by banks and financial institutions. So you want to make sure that the document is going to give your attorney-in-fact the power to do the thing that your attorney-in-fact needs to do when he needs to do it. So one thing to note about that, you also want to make sure that you want to name a backup. So you name your first attorney-in-fact, the person that you feel most comfortable taking care of you, paying your bills, deciding where you're going to live, managing your income. Then you want to name a backup to that person so that the document does not fail for lack of a person named in the document. I tend to tell my clients to name at least probably 3 people on the document: your first name person, a backup, and then a further backup, just to be safe. There are all other kinds of things this document should have. It should have your waiver of the HIPAA laws. Very important provision you need to have in this document, waiving your rights to HIPAA for your attorney-in-fact, so that your attorney-in-fact is not barred from receiving any information that might be protected by that federal law. Advanced medical directive is sometimes, I call this the medical power of attorney. This is the document where you name the person that you want to make your medical decisions for you when you can no longer communicate to your doctor yourself. This is a legal document that gives a person, your medical agent, legal authority to make your medical decisions when you are unable to do so yourself. It includes your medical decisions, your end-of-life decisions. It's really important that your document have your end-of-life decision so that you get to make that decision. And that decision's not going to be left up to your family to make, which is a big burden upon them, to decide your end-of-life decision, or, God forbid, leave it up to the physician in the hospital to decide when to withdraw artificial life support or when to keep the artificial life support on your body. So this document, you need to have your end-of-life provision, and your attorney will talk to you about what that entails. It would also have a do not resuscitate order. So following the language following your end-of-life decision, you'll see that do not resuscitate order, because if your end-of-life decision is that you want to have all means of artificial support withdrawn so that your body can just die of its natural course, the do not resuscitate order is there to prevent the hospitals from resuscitating you and bringing you back to that permanent dying process. Here is an example of a will package for a married couple. So we see husband's will in the blue box, wife's will in the pink box. Typically, husband and wife's will name each other as primary beneficiaries. So each of their wills will name each other as the primary beneficiary, and then each of their wills will name their children as the contingent beneficiaries. Sometimes these are referred to as I love you wills. Typically, not always, but normally, if I have a couple that comes in and they want to do wills, I typically will tell the couple that they want to keep all their assets jointly titled during their lifetime, so that when the first spouse passes, all the assets will flow automatically to the surviving spouse, so there would be no purpose for filing the first to die spouse's will. The only reason that you would file the first to die spouse's will is if there was an asset that was in the sole name of the first spouse to die. So usually you want to avoid the surviving spouse having to probate her husband's will, because there are costs. Those assets are subject to the probate tax and the probate process. So you want to avoid that. There's no reason to have to go through that process or pay that tax if you wanted your wife to inherit that. So you keep all your assets jointly titled, so that upon the first spouse's death, everything will flow to the surviving spouse. And And then it's going to be later when the surviving spouse dies where you're going to see the assets have to go through the probate process. Okay, so just because you have a will does not mean that you escape the probate process. The will has to be supervised by the court, and your assets still have to go through that process. But the will can do things like I mentioned before. Name who you want to serve as your executor, name who the beneficiaries are and contingent beneficiaries, waive the bond, and provide for sub-trust to protect your children's inheritance. But the will still has to go through a probate process, and typically it takes about 1.5 to 2 years to get through probate. Okay, we're going to talk more about the probate process here in a moment. Here is a diagram by Henry Apps, which, by the way, Mr. Seidel used to give estate plan presentations with Mr. Apps. So Jim Seidel knows the man who's written lots of books and literatures on the living trust and the probate process. So he prepared this diagram to show you the different stages of the probate process. And sometimes, you know, you might have a will going through probate and it may not be so bad. Maybe, you know, there wasn't any complications and everything got through okay. But if the will gets hung up in any of these side boxes here, that's when it can take a long time. So it's always hard to know what in the beginning what the process is going to be for that particular will and those assets until you get involved in the process. But it usually takes about 2 years. The reason why it takes a couple of years normally to probate a will is because when you die, your will is a matter of public record, and anybody off the street can come into the courthouse and ask to see your will and ask to see an inventory of the assets. The court puts a notice in the newspaper that you have passed and that your will is being probated. So that alerts any creditors that you might have, or anybody that thinks that you owe them money. They have a right to come into the courthouse, look at your will, look at the assets, and then file a claim against your estate. So the government says that there has to be a certain amount of time has to elapse, usually 6 to 9 months, depending upon the jurisdiction. But they want enough time so that any creditors that feel like you owe them money, they have a right to come and make their claims known. So that's why the government is not going to let the executor make a distribution of the assets too soon. The executor is told from the very beginning that she has to pay all the bills, legitimate expenses of the estate, but she shouldn't make any distributions to the beneficiaries until she's satisfied that she's identified all unknown claims and filed your last tax return and paid your taxes, which, by the way, the tax return and the taxes usually pushes the probate into a second year because she's not going to know what your tax status is until the end of that first year. And then she's got to get an approval notice back from the IRS and the Commonwealth of Virginia that they are satisfied and they don't expect any more money before she can make a distribution to the beneficiaries. So you see how this is holding up the distribution of your assets to your loved ones for at least a couple of years. The poor man's estate plan is another type of estate plan that many people resort to escape their loved ones from having to go through the probate process. I see this a lot with surviving spouses. So if I've got a husband and wife, they're using will packages, the husband dies and everything flows automatically to the wife just by title of the asset, and the husband's will is not used because all the assets went automatically to her. Then that's when I start seeing the surviving spouse, she gets worried. She knows that when she dies, she's sitting on all the assets, and when she dies, there won't be a living owner on the asset to receive that asset, and that asset has to be supervised by court and the probate process. So she will run out and put her children on her assets. So, she thought, well, this worked fine with my husband. Let's see if it'll work okay with my kids. So she'll put little Johnny on her house. Quick claim deed the house over to little Johnny. We're going to talk more about that in the next segment.